We'll go on the record now in Lee versus Lee. This is file number 2419864. If I could have counsel for both sides put your appearances on.
Yes, good morning, Your Honor. This is Matt Motley appearing on behalf of the plaintiff.
Good morning, Judge Elliott Blumberg on behalf of the defendant, who's actually in my waiting room. Can I just wait a moment to bring him in?
Sure, absolutely. All right, the record should reflect Ms. Lee is also connected by Zoom video. This is set as a status conference in this file today. Mr. Motley, on behalf of plaintiff, can you tell me where things are at? I think this is your first appearance on the record anyway for Ms. Lee. So can you tell me from your standpoint where things are at and what we need to do for scheduling going forward?
Change the scheduling. I mean, I'll just start by saying I think 90 days of discovery would be sufficient. I know we still have that pending hearing with the friend of the court coming in September for the issues relating to custody, parenting time, and child support. So if nothing gets settled before then, I anticipate that hearing would resolve those matters. But either way, I think 90 days of discovery would be sufficient, giving us maybe 120 days to mediate. I'm confident that we can select one in advance of that. So I think that as be a starter here is just getting these next steps done.
Thank you, Mr. Blumberg.
Judge, while I don't disagree with counsel's request in terms of discovering and scheduling, there is an ongoing violation of your court order. Ms. Lee continues, in spite of your order, to deny my client parenting time. We continue to file complaints with the friend of the court, but hearings aren't scheduled out until September or later. I think you'll remember that Ms. Lee was represented by prior counsel. We had most of the day to come to an agreement. There was a signed agreement prepared. Ms. Lee fired her attorney and then refused to sign the order. You subsequently signed that order, but she continues to ignore it, and my client does not have the opportunity to see his kids. So if you want to know the status of the case, that's a major problem right now.
Okay. Mr. Motley, have you discussed that issue with your client?
We have, and I mean, we more or less filed an objection. I mean, again, without getting into the substance of what this is, what the agreement or the alleged agreement happened. Obviously, I think we have a different position on this. I'm understanding that there's a hearing set in mid-September to address these issues. Otherwise, I think the parenting time's been going on schedule, but I think the major point was the no contact order due to the pending criminal sexual conduct case against the defendant here, that he's not supposed to be at these pickups, which I thought was a major term of the agreement. That, again, I talked to her attorney. I don't know all the substance of the agreement, but I know if the parenting time schedule that was in place is supposed to be in place, that he was not to be doing these pickups and drop-offs just by virtue of the no contact order that's there. And it's my understanding that he's been going to these. That is one piece of it, but again, I don't want to get into the substance of that today.
All right. Well, I mean, that's an issue that's going to have to play itself out, you know, according to the normal procedures of the court. I guess I would just say, you know, there is an order in place, Mr. Motley, to the extent your client is not following that. And you guys, you know, everybody's going to have a chance to argue about whether that order should stay in place or not based on what happened previously. But the fact is, there is a court order in place, and to the extent that your client is just willfully violating that because she doesn't agree with the way that order got entered, that's not a reason to just not comply with the order. So all I would say is, to the extent that she's found to be failing to comply with that order and not having any legally justifiable reason for doing so, I just think you need to caution your client that the court, I would fully intend to use the full weight of the court's contempt sanctions to compel her to follow that order if it's not changed, and she needs to be following it now. And to the extent, Mr. Blumberg, that your client is doing something that's in violation of that order, that only hurts your client in terms of his ability to have that enforced. So I think both sides need to follow the order to the extent that either the referee or the court or both find that neither side has appropriately followed it or either haven't. I am not going to tolerate from either of these individuals, Mr. Lee or Miss Lee, just ignoring the court's order. in particular, in this case, I think the court needs to take a hard line with both of these individuals, because I think they both just want to do what they want to do, and that's just not going to happen. The court's orders mean something, and to the extent that either side isn't following them, both Mr. Lee and Ms. Lee need to be prepared to pay the price for that once that's determined. So that's all I'll say with regard to that. This is a status conference. This isn't an evidentiary hearing. I'm not going to make any findings on that, but I just want both counsel to caution your clients that I'm just not going to tolerate it in this case. And again, in particular, based on the evidence that I've heard so far as to the actions of both parties. So that being said, I do think, and there was no objection to it, I do think Mr. Motley's suggestion in terms of scheduling is appropriate. So the court will enter that in terms of a scheduling order. 90 days for discovery, mediation to occur within 120. The court will set this for another status conference at that point. Otherwise, the parties will proceed in front of the court, and to the extent there are objections to the front of the court rulings, we'll get those scheduled in due course as well. Mr. Motley, is there anything else that I can address for your side today?
I mean, there are minor stuff like the witness list and exhibit list, but I assume the court's just going to outline that in the scheduling order that's going to result from today's hearing.
Well, yeah, I mean, if we need to, this is going to get us going up through mediation. If there aren't any agreements, then we'll set additional dates for court hearings, and we'll schedule those types of matters in with that.
Yeah, that's all I had, Your Honor.
Okay, Mr. Blumberg, anything further from your side today?
No, Judge, thank you. I appreciate you addressing my concerns. Thank you.
All right, thank you. That's all for today. All parties on this file are free to disconnect.
Good afternoon, Judge Elliott Blumberg, on behalf of Alma Carr, the plaintiff, who's appearing via Zoom from my office.
Thank you, Your Honor. Jason Thompson, on behalf of Defendant Scott Carr, who's with me in my office. Thank you.
Okay, we're set for a status conference in this case today, as well as Mr. Carr's motion to set aside the default. I did have a chance to read the motion. Mr. Thompson, did you have any argument you wanted to present?
No, we would rely on the written motion. Thank you, Your Honor.
Thank you. Mr. Blumberg, are you objecting to the motion?
We are, Judge. We've filed a response as well as a brief in opposition to the motion. My understanding that the court rules require the filing of a brief whenever there is a motion that raises questions of law. While I appreciate the motion, it doesn't give the court, doesn't establish for the court the authority to set aside the default. We all know what that is, obviously, but certainly the salient facts is that Mr. Carr has been in default for about 10 months now, has not participated in any meaningful way in this case, hasn't filed any financial information, the result of which was it cost my client a significant amount of money to get his pension valued, to determine what the value was. Based on that valuation, his military pension was significantly more valuable than my client's. And so we came up with what we perceived to be a fair and equitable division of the military pension. Again, there's been no showing of good cause, no showing of the existence of a meritorious defense, and even the affidavit signed by Mr. Carr doesn't really establish either of those requirements. I think that we were most recently before you attempting to get the judgment entered, and at that point, Mr. Carr indicated his desire to retain counsel. So it's a little late in the game. There hasn't been a proper showing of good cause or a meritorious defense. And ultimately, the division that we're asking the court to adopt in this judgment of divorce is both fair and equitable. So I would respectfully ask the court to deny the motion.
Thank you. Mr. Thompson, anything you wanted to state in response?
Just that, Your Honor, I appreciate counsel's remarks. I mean, Mr. Carr is not privy to any evaluation that's been performed. I don't believe the court is either, so I don't know how the court would be in a position to weigh in on the reasonableness of the judgment. Mr. Carr has, I would suggest, participated certainly not correctly, but he has appeared multiple times for Zoom hearings, has negotiated much of the estate here in good faith and in a fair manner. The sticking point has been this retirement issue. I've heard counsel's representations about how they were divided. I would respectfully suggest the adversarial system would allow the court to have confidence that it is a fair and equitable division. Thank you.
Mr. Thompson, just to clarify what Mr.
Yes.
Carr's position is, I mean, is the pension division, the sense I got from your motion is that the pension is the real issue here.
It is.
I mean, are you looking to relitigate everything, or is it really just how this pension is divided up? That's
Just the pension and retirement. I believe the motion indicates that my client did agree and that the division of the real estate and the cash assets were appropriate and fair. And yes, the remaining issue is Ms. Carr's retirement versus Mr. Carr's retirement and how that is valued and then divided.
Okay. All right. So looking at the law that applies in this case, it is a different court rule than it applies to defaults in civil cases generally. Under MCR 3.210B3 in domestic relations actions, the court can set aside a default for good cause. Under MCR 3.210B2D, the court can permit defaulted parties in divorce actions to engage in discovery, to file motions, to participate in court hearings, mediation, and other ADR procedure. In light of defaults, the court can impose limitations on that participation based on the circumstances of the default. And the court has to recognize that different from typical civil actions, divorce cases are equitable actions where the court has an obligation to make sure that any property division and any default judgment that might result from a default is nevertheless equitable. Looking at the facts in this case, Mr. Carr did participate with Ms. Carr in terms of trying to reach agreements. So in that regard, he hasn't just not participated at all. He has appeared for court hearings on his own. So he wasn't defaulted because of his failure to participate with the court or some type of sanction for misconduct or so forth during the pendency of the case. I think it's significant that Mr. Carr is not trying to invalidate all the agreements that were made between him and Ms. Carr. He's just seeking to ensure that the retirement pension is being fairly divided. In my view, he's raising a very limited issue that the court would have to determine the fairness of anyway under 3.210B5E. Even if the court were not to set aside the default. The court certainly would have to hear arguments before entering a judgment as to why, and make a determination as to whether or not and why plaintiff's proposed division of the pension was fair and equitable. So for all those reasons, the court finds there is good cause and it would be appropriate to set aside the default. But again, pursuant to court rule, the court is going to impose a limitation. And that is that the sole issue for further negotiation and resolution is the fair division of the retirement and pension of the parties. So the court will grant the motion as indicated here on the record. Mr. Thompson, if you would prepare an order that reflects that ruling of the court. And then in terms of scheduling, I mean, Mr. Thompson and Mr. Blumberg, both of you want to have a chance to exchange some documents on this issue, or how do you want to proceed, Mr. Blumberg, on behalf of the plaintiff?
Well, Judge, I fully appreciate and understand somewhat the court's ruling. My understanding of the court rule is that before the court sets aside a default, those fees that were incurred as a result or in reliance of the default has to be paid by the opposing party. I think that that is a condition upon which the default to be set aside. And the reason why that's important is, again, as I pointed out, we've had to do all the discovery on our own. He has provided no documentation in regard to any assets, let alone his retirement. My client has expended, as I pointed out, a significant amount of money to get his retirement valued because he didn't provide us any of the information. So I would respectfully ask the court, if the court is going to set aside the default, I think my client's entitled to those fees incurred in reliance of the entry of the default.
Okay, if you want to submit a bill of costs and copy Mr. Thompson on that, then the court will take up that issue.
Thank you.
But in the interest of getting this resolved, I would like the parties to, I'd like to, as part of the status conference here, get some dates for going forward. So again, in terms of how to proceed, Mr. Blumberg, do you want to have a chance to have some negotiations with Mr. Thompson? Do you want the court to just set a mediation deadline today?
I'm certainly we're in a position to provide Mr. Thompson with the documentation that supports the division that we've requested. We'll share that documents, and he can certainly feel free to review them and make whatever determination. I don't know what other discovery really needs to be done. We'll provide what other information he needs.
Okay, Mr. Thompson.
Your Honor, in anticipation of today's hearing and this possible ruling, I did have my client prepare the financial information disclosure, so we're prepared to exchange that. So I think if we had a little bit of time to look at Mr. Blumberg's materials, he would certainly be able to look at ours. And then I think a mediation, 30 days out would be appropriate.
Okay, so I'm going to have discovery remain open for 60 days. The court will refer this to community mediation to occur within that 60-day period. And then I'll set this for another status conference at that point. Mr. Blumberg, if you submit your billing to the court will enter an order without further hearing on that issue. And then if the parties are able to reach an agreement prior to that next status conference, I'd be happy to give a date. Otherwise, we'll see where we're at 60 days. We can always use that as a date to enter proofs as well.
Thank you.
Mr. Blumberg, anything further from your side today?
No, Judge, thank you.
Mr. Thompson.
Well, I guess, Your Honor, I'd like the ability to object depending on what bill of costs come in. I mean, if it's a motion for entry of default judgment, that's certainly contemplated. I believe Mr. Blumberg was describing all their discovery efforts, and I don't know if the court is ruling those are all costs incurred in reliance of the default at this point, or if we would have an opportunity to object.
What I'd like to do is get the bill from Mr. Blumberg. I'll issue an order, but I would give you an opportunity, Mr. Thompson, to the extent that you have an objection to the court's order to file an objection to that and have a hearing. I think that would be fair.
All right, I will review that when it comes in. Thank you.
Right, but I guess my point is I'd like you to be able to see what the court intends to do, rather than have a hearing about things that may not be an issue.
I understand. I'll follow the court's procedure. Thank you.
All right. Okay, that's all for today. All parties are free to disconnect at this time. Thank you.
Thanks.
Okay, we'll go on the record in Peters versus Peters. This is file number 2419704. Ma'am, you're Hannah Peters, is that correct?
Correct.
Okay, and this hearing was set for 9:45. It's now 9:48. I do not see Mr. Peters present, but we do have Ms. Peters present. This was set for a final hearing today. The court spoke with the parties back in May. They were supposed to attend the SMILE presentation and submit a judgment to the court. I do have a note here, Ms. Peters, that you appeared at the front of the court office on Friday afternoon. And with a proposed judgment, which could not be approved because you had not yet attended the SMILE program. And then I have a note here indicating that you told the caseworker that she was wasting your effing time.
Oh, no, sir. I did not say effing time. I actually said this is a waste of my time. I was not told previously that I would have to have that SMILE program done before they could sign off on the judgment papers. And so I was not aware that that would not be signed off at that time. I feel like I've been getting a little bit of a runaround when it comes to the front of the court. I do have a, SMILE program set for tonight through Kalkaska. That is the only thing holding it up, and I'm not really sure why, because I've talked to many people and nobody else has had to do the SMILE program, and I've had to do the SMILE program before. I've already been through it, and so I guess like it's just, and it's only once a month, which is really hard for me to get to, and I have 2 kids and a full-time job. My kids were sick the last time I had the SMILE program, and I was not able to make that one, and so this was the next one. And unfortunately, it was for tonight.
Okay, so just want to clear a couple of things up. First of all, you were told multiple times that you had to attend the SMILE presentation, including by me at the last hearing in May on the record. So that's incorrect. Everybody who goes through a divorce with minor children has to attend the SMILE program. So whoever's telling you that is incorrect, and you're aware of that if you've been through it before. This is now the 5th hearing that I've had with you and Mr. Peters since January, where both of you have been repeatedly instructed about what you need to do. So claiming that you didn't know what you needed to do and that you haven't had 5 months now to attend one of these is just incorrect. And we're not going to tolerate you being rude to staff because you're not doing what you're supposed to be doing when you know what you're supposed to be doing. And I get that you're frustrated, but the fact that you haven't done what you need to do and what everybody going through a divorce needs to do is not a reason to take that out on the people who are just telling you what they need you to do so that we can take care of the business that you want to take care of. You're the one that filed for the divorce in the court. We didn't ask you to come in and get a divorce. You're asking the court to take care of this business for you, and we're telling you what we need you to do in order to do that. And if you're not going to do it, I'm not going to keep scheduling hearings and wasting my time. So I'm going to give you one more opportunity. If you haven't taken care of what needs to be taken care of by July, then I'm just going to dismiss the case and you can refile it and start all over again at the beginning. So the ball's in your court at this point. Do you have any questions?
No, I do not.
Okay. All right. Thank you. That's all for this hearing today, and you're free to disconnect at this time. This is set pursuant to your motion today. Ms. Richards, I did have a chance to review your motion at the proposed order. What would you like to say today in support of your motion?
Your Honor, we are just asking the court to order that Penelope Vanderkuchov is a child born not of the marriage. The alleged father is Mr. Luke Vanderkuchov. He is willing to pursue paternity if the court does order that, and all parties have held out that the child is not born of the marriage since conception.
Thank you. Mr. Blumberg, do you have an objection to the motion?
No, Judge, I think everybody acknowledges that my client, the husband, is not the father of this child.
All right. Mr. Luke Vanderkuchov, have you been able to hear what was said so far?
Yes, sir.
Do you have any objection to the court entering this order today?
No, Your Honor.
Okay. So the court will grant the motion. I will sign that order as proposed by Ms. Richards. Mr. Blumberg, have you had a chance to review that proposed order?
We have, Judge.
Do you have any objection to the form?
No, I do not.
Okay. All right. So the court will sign that order. Ms. Richards, anything else that I can address for your side today?
No, Your Honor, thank you.
Mr. Felberg?
No, Judge, thanks.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.